Hello and welcome to today's webinar hosted by Merkle Science. Hopefully, most of you in the audience would have heard of us before, but for those of you who have not, Merkle Science is the next generation predictive cryptocurrency risk and intelligence platform that aims to detect, investigate, and prevent illegal activities involving cryptocurrency. In our company, we envision a world powered by cryptocurrencies, and through the innovative solutions that we've created, we are creating the infrastructure necessary for the healthy and safe growth of this $22 trillion financial services ecosystem. Together with my amazing colleagues spread across Singapore, New York, London, and Bangalore, we support crypto businesses, financial institutions, regulators, and law enforcement agencies globally. So my name is Ian, and I'm honored to be the moderator for today's session on mastering compliance, how Web3 firms can thrive under Hong Kong's new crypto regulations. As many of you in the audience might be aware, earlier this year in June, Hong Kong introduced a couple of new regulatory changes that opened up the crypto market to retail investors, whilst introducing a mandatory licensing framework for crypto exchanges. This has led many Web3 firms to seriously consider setting up offices in Hong Kong. And as someone who actually spent the last year in the US, San Francisco, I can personally attest to the fact that I've had many interested clients and partners reach out to me to inquire about Hong Kong's latest regulatory development and how it might benefit them if they were to move. With that said, this webinar couldn't have come at a more opportune time, and I'm very excited to be joined today by my esteemed panelists, Urszula McCormack, Robert Zhan, and Jonathan Gill, who between them have a wealth of experience in advising Web3 firms on how best to navigate the Hong Kong crypto landscape. With that, may I invite my panelists to say a few words to introduce themselves. And with that, perhaps, Urszula, if you'd be so kind to start us off, followed by Jonathan and then Robert.
Thanks very much, Ian, and such a pleasure to be here. And I can see in the attendee list so many wonderful familiar names. So I hope this is as valuable to you as people who've been in this sector for as long as me, perhaps longer, as others come into this fresh. So my name is Urszula McCormack. I lead the KWM FinTech and Blockchain team, and I've been in the space for a long time as a regulatory lawyer. So my areas are financial regulation, financial crime, and data regulation. And we've been in the crypto sector having a lot of fun with it since about 2017.
Right, yeah, I'm Jonathan Gill, and I'm a Senior Tokenisation Director at Hashkey. So I structure and execute token offerings, and then the other part of my practice is advising on virtual assets regulation for Hashkey and in our various jurisdictions, including Hong Kong.
Hi, good afternoon, everyone. My name is Robert Zhan. I'm a director here at KPMG Hong Kong. I lead our virtual asset service offering, is particularly around the regulatory requirements from here. We're definitely very excited to be here in Hong Kong at this time. And, as every other professional services firm, we are looking to support, see what we can help with in this sector. Personally speaking, I've been involved in crypto assets since 2018. So I'm definitely, have a very favorable outlook in this sector. And hopefully, and I think, we're very supportive of the Hong Kong's current regime and what the Hong Kong government is planning to do in this sector. And we look forward to working with many of you.
Thank you all for your kind introduction. So between the three of you, I think we have great representation, from the legal side, from, a licensed applicant themselves, as well as then, one of the biggest Big Four consultancy firms. As for myself, I am part of the founding team at Merkle Science, where I actually serve today as product strategist for our intelligence platform. And prior to joining Merkle Science, I started my career in the capital market space as a lawyer, and since then have been applying my knowledge in the legal and regulatory space to help develop innovative solutions to help crypto businesses stay safe. But enough about us. Now that we've gotten the introductions out of the way, let's dive straight into it, as we do have quite a number of interesting topics to cover. For members of the audience, I'm pretty sure that as the webinar progresses, a lot of you may have questions of your own that you'd like to pose to the panelists, right? So if you do have questions, I ask that you please post your questions inside the chat, and I will be reserving some time at the end for us to address them, right? And in the event that we do run out of time, rest assured, I'm sure if you send in the questions, we'll be happy to circulate them among the panelists, and we'll get back to you offline, right? But with that said, let's dive straight into it. So as many of us are likely aware, Hong Kong has been positioning itself as a crypto hub for the last couple of years, and this has led to many numerous regulatory developments. Robert, if I can invite you to kick off this discussion by kind of setting the stage for everyone. If you can kindly share how the efforts of Hong Kong, if you could kindly share, what are some of the efforts that Hong Kong has taken to position itself as a crypto hub? And how has some of the more recent regulatory changes in Hong Kong impacted the operations and licensing process for virtual asset service providers and trading platforms?
Yeah, most certainly in this regard. So I think we all understand that really the whole regulatory landscape started changing back in 2019 with the SFC circular around the opt-in regime for the voluntary virtual asset trading platform. So how that came about is, as we all know, under the Security Futures Ordinance in Hong Kong, the SFC really only has regulatory authority over security tokens. We consider everything sort of crypto related. And as Jonathan would definitely can speak to, one of the requirements to be opted in is to be able to be offering at least one security token on the platform. So not many firms will be allowed to be regulated, even if they wanted to, if they did not have any security token on the platform. And that's really, in my view, was the first major milestone that happened here in Hong Kong. And throughout 2020 and towards 2022, there were a few other circular issues. For example, there are the circulars regarding how intermediaries should interact with virtual asset services, particularly on distribution and dealing of virtual asset related funds. This had garnered some attention from some of the brokerage firms and also the asset managers, more from push factor by their clients. But as you know, with the crypto sort of scene started dying down, this also sort of went away with it. And it's not until I think really in late 2020, with the view that the new VASP regime is going to come in, things really started picking up again. And this really sort of is driven by the Hong Kong government. As Ian rightly mentioned, the Hong Kong government does want to make Hong Kong not just the digital asset center of Asia, but also the fintech innovation centers of Asia. So the digital asset is definitely one of the key pillars under their mandate to make sure that we are bringing the right talent, we're bringing in the right innovation, and we have the right people here in Hong Kong. And that is sort of the latest development that is has been legislated, and you could see that it actually moved quite quickly. The legislation happened in late 2022, and the SFC has formalized the regime, and this has now been in effect since June of this year. And we know there's going to be more to come. For example, there are still question marks around derivatives, crypto derivatives. There are still question marks around what can be offered to retail investors. And there's definitely still question mark around security tokens, and also what is the HKMA's view on stable coins. So these are all exciting topics. And I think there's going to be quite a bit of interest still from us as consultants, and also to see exactly what will formalize over the next year or two around all of these topics.
Thank you, Robert. And you've highlighted, I think, a couple of interesting topics that hopefully, if we have time today, we can circle back to, to where we can dive more into, what is a security, how are these classifications evolving. But with that said, actually, Urszula, Jonathan, is there anything that you guys would like to add in?
Just a quick addition. I think one of the most interesting developments for Hong Kong actually happened in 2014, which is when the Customs and Excise Department said that it was not going to take applications from crypto companies for money service operators. And why that circular is so important, it was the time that Hong Kong set the scene to say that no crypto was currency. And that has made it so much easier for people to innovate in Hong Kong, because you don't have the money transmission regulatory hooks as quickly as you do in other markets like the US. I wanted to point that out because that circular was such an interesting development at that time. The other one I wanted to say is just the impact of government messaging. You know, we've had a really significant regime for crypto for so long, but when I'm in Dubai, when I'm in Australia, when I'm in London, you do hear, you know, the strong and positive messaging of any government really come, you know, through very strongly, and also have a significant impact on banks and other ecosystem providers. So I think that that particular piece around, you know, government support that, you know, was raised as well has been so important for Hong Kong.
Yeah, I totally agree. I think one of the most important things you can do as a jurisdiction is to provide regulatory clarity and government support. I mean, you know, to Urszula's point, when you see jurisdictions that actually seem to be unfriendly to Web3, it's generally because their regimes are unclear, or they don't, you know, their governments don't engage with the industry, or, you know, worst of all, they have regulation by litigation. You know, so when, you know, we hosted our own Web3 festival earlier this year, and we were really pleased to see how much, you know, government presence there was and interest in virtual assets. So it makes us feel very good as a licensed operator in terms of Hong Kong actually being a hub for crypto.
No, thank you all for your insights, and I couldn't agree more. I think, you know, regulatory clarity is vital in helping spearhead, you know, technology growth. A lot of the crypto companies that we advise oftentimes struggle to understand if what they're offering is something that's caught under applicable laws. And so what that tends to lead to is a lot of jurisdictional arbitrage, where companies constantly hop to find jurisdictions where, you know, their current offering still remains unregulated. That being said, a lot of them, you know, given the choice, would like to be regulated. They just don't know, you know, which country to go to and what the specific requirements are. So having that kind of clarity, I think, is super important. Now, it's one thing to read about new regulations, but oftentimes, you know, going through the process might be slightly different. And I'm very pleased to say that we have with us here today, you know, Jonathan from Hashkey, who, like I mentioned, was the first FSC licensed virtual asset exchange that successfully had their Type 1 and Type 7 licenses upgraded, which positioned them as the first licensed trading platform in Hong Kong to offer retail services. Now, I'm sure there are many of you in the audience today who envy Hashkey's position and would love to find out more. So Jonathan, to the extent possible, without sharing too much trade secrets with, you know, potential competitors, can you share a little bit about your experience in that process, and what are some of the challenges and opportunities that companies might face in trying to obtain a similar license?
Yeah, sure. I mean, I guess just to sort of zoom out a little bit, Hashkey has been in the regulatory process for quite a long time. So we actually started applying for our virtual asset 1 and 7 licenses in 2019. We got our AIP, that's approval in principle, in May 22, and we got our full license in November 22. So, I mean, when the VATP license came out this year, we were already, you know, in the SFC sites. They sort of knew what we did, what we could do, and so on. And so we were thrilled to be the first licensees under the new regime. So that's a little bit of background about Hashkey and why we, you know, our sort of regulatory journey. So you've asked about challenges. To be honest, there are a lot. You can expect many rounds of questions from the SFC. So a lot of it is, you know, determining to the SFC satisfaction that you've got the policies and procedures, firstly, and then secondly, that you can actually implement that. So it's about talking the talk and then literally walking the walk. And I mean that because you have 2 external assessment reports. So phase 1 and phase 2. So phase 1, you know, you are actually saying what you want to do, and phase 2, you know, the SFC's got a bit of an idea of what you do, and then actually proving that you can do that. And then in addition to that, you also have to submit a lot of things. You know, you've got the personnel, you've got the KYC, AML, CTF, investor protection, solidity behind you, and the tech. And so you can expect, you know, rounds of questions about penetration testing from a tech perspective. You know, you get a lot of questions about, you know, your personnel and the experience. And I mean, the SFC, when they do this, you have to remember they hold us to the standards that they would hold, you know, a securities exchange to. You know, if it's the London Stock Exchange, the Hong Kong Stock Exchange, it's that kind of level of investment grade securities exchange. And I guess in terms of opportunities, I mean, that's probably a good thing for us, because we can actually demonstrate to investors or people from other jurisdictions that the stand that we've been held to is really at an investment grade. And I think that's a good thing for Hong Kong, not just for Hashkey, because it demonstrates that Hong Kong is serious about having a very compliant regime. I think, you know, to spin it around the other way, if you look at some other regimes that they've been supposedly crypto friendly or light touch, you've seen that they're actually the regimes where there have been crypto collapses.
No, that makes a lot of sense, and it sounds like, you know, you guys had a advantage given that you had already, you know, submitted a license application before, so a lot of the framework was probably in place, right? With that said, then, would you say that, you know, companies who are licensed in other jurisdictions would find it easier to perhaps, you know, apply for a license in Hong Kong, given that they might have, you know, a lot of the framework already in place? Or, you know, given your experience in advising across different jurisdictions, you know, are there regimes out there which are, you know, perhaps more similar, and so having a license there might make it easier? And I would love to invite, you know, Urszula and Robert to chime in as well, given that I know both of you advise companies across multiple jurisdictions as well.
Yeah, well, I mean, we're a Hong Kong company, so this is really where our headquarters are. But having said that, we've got licenses in Japan, AIPs in Singapore. Hong Kong is sort of our home, though. I think, you know, to answer your question about whether it's easier or not to have if you're a licensed entity somewhere else, I think it really does depend on the jurisdiction. Every jurisdiction is slightly different. They have slightly different focuses. You know, Hong Kong, for example, has got a very strong investor protection focus. Now, that's sort of different to, say, Singapore. You know, they've got, when they started, they were sort of more payments AML focused. So I mean, we approached Singapore with the MAS in a slightly different way to how we approached the FSA in Japan. Obviously, if you've got, you know, the right people and you know, solid processes, I mean, that's going to stand you in good stead in any jurisdiction. But I wouldn't say that, you know, just because you've got a license somewhere else, it's going to be an easy process in Hong Kong. I mean, even here now, I mean, there's us and one other virtual assets company who have got our uplifted 1 and 7. So it's despite there are many other entities who are applying at the moment.
No, thank you. And Urszula, Robert, did you guys want to chime in with anything as well?
Yeah, look, it's such great comments. What we see for a lot of the offshore exchanges is there is a lot more work to be done from the ground up and reinventing some of the controls to fit the granular requirements. I think one of the significant upsides of the SFC regime, of course, is that standards are granular. And so the expectations are quite clear, and you'd expect that from such a heavy-hitting, you know, quite sophisticated regulator that's really wrapped its arms around crypto, unlike other markets where they've really just had an AML or an MSO type approach. But I do find these clients that even when it comes to sort of AML rules or custody, where you might say actually there's a lot of sophistication, practical sophistication around custody controls, we are still having to sort of reframe them, reshape them, make sure that we're, you know, ticking all the boxes. And when I talk about ticking all the boxes, we've just completed a large exercise around doing a full-on obligations register, peeling out all the obligations out of forms, out of the EARs and so on. that list is quite monumental. So these are big projects like we went through with virtual banks, like we have with SVS. These are very highly regulated institutions. But look, what I would say is that we know that a lot of what Hong Kong is doing is informing. And look, I should give credit to other jurisdictions, UAE as well, but they are informing global standards. So SFC is a fairly early mover on the granularity of those standards, but it is informing and shaping others. So I would say that that pain that many exchanges are going through in Hong Kong would genuinely be incredibly valuable when it comes to compliance with the rollout of those standards globally.
Yeah, I think Urszula and Jonathan sums it up pretty well. At the end of the day, the SFC is going to first and foremost want to protect the reputation of the jurisdiction. Hong Kong is a first-tier capital market, and the SFC and HKMA, the overall financial sector, is really seen as one of the top regulators in the world. So they're not going to allow just anybody with a license overseas to have an easier process. And in our view, I mean, we have also spoken to certain applicants that have license overview. And of course, one of the questions that usually get raised is, we already have assessor done certain assessment in our AML program. Does that make our work reduce from the KPMG China side? And the answer usually is no, because we need to satisfy ourselves. And we actually have done exercise like similar to Ursula's to see where the gaps are between different regulations, even specifically at looking at AML. And although AML is probably the one of the area that's most consistent across jurisdictions, there are still differences. And you can see that from just the level of detail the SFC in the handbook has released for virtual asset service providers. And I think like Jonathan mentioned, or sorry, I forgot which one, but the investor protections is super important for the SFC. I don't believe any other jurisdiction, at least not to my knowledge, has specific requirement around a token emission committee. And I think market surveillance is also one where we are only seeing in limited other jurisdiction that has crypto regulation. So overall, if we do a mapping across, let's say, the 8 assessment area that's required by the SFC, we could say that SFC is probably on top of their game relatively to any other regulation in the world.
Thank you all. And I couldn't agree more. Again, as an ex-lawyer myself, it's always great if regulations are specific rather than vague, because, in an industry that's constantly evolving, it can be quite challenging trying to interpret some of the regulations that have been put out in some jurisdictions. So this nicely segues onto the next topic, which I wanted to bring up, which is AML. But before we do that, I do want to point out that, I have noticed a number of questions that have come in. So thank you. We do appreciate that. Don't worry, we're not ignoring your questions. Like I mentioned at the start, I have reserved some time at the end for us to address those questions. So if you have more questions, keep them coming, right? But with that said, as part of the licensing requirements, like you guys mentioned, a topic that always comes up without fail is the topic of AML, right? How can businesses safeguard themselves against potential money laundering risk, given that the crypto space is undeniably fraught with illicit activity? So this has obviously been made all the more complex with the emergence of new tools, as well as the technology itself, transparency provided by the blockchain. And so it can oftentimes be a struggle for companies to understand all these new risk factors. Ursula, given your experience in helping a number of these regulated entities in the space with their AML, can you provide some guidance for the audience as to how companies can get ahead of their AML risk, and how might they think about using technology to enhance their current monitoring capabilities?
Yeah, look, very happy to. So we've been in AML for a good 12 years since the AML was implemented, and we've been working with the banks primarily, but increasingly with crypto institutions. And I think what bothers people in the crypto scene so much is that when you talk about the crypto scene as being, high risk from an AML perspective, often, people will rightly say it's actually the worst asset, type of asset to use unless you're using a privacy, enhanced asset or a tumbler and so on, because of the transparency that public blockchains bring and the incredible tools that are now available. But look, the issue is that naturally we still have pseudonymous, wallets. We still have a lot of illicit activity that occurs, and the rules, on crypto institutions, and particularly in Hong Kong, are very tough, right? But it is the case that this will assist banking relationships, and that's probably one of the best stories to come out of Hong Kong. Is that we have many of my banking clients who are super conservative, calling us up and saying, "Okay, we need to bank this sector. Tell us how we do it." But from a crypto institution perspective, there's sort of 5 key pillars, right? So the first one is policies and procedures. It all starts from there, and on any investigation, any audit, it always comes back to policies and procedures. It's the AML policy, the sanctions policy, the transaction monitoring policies. And a lot of those are quite straightforward in terms of matching the requirements that you need to meet in Hong Kong. The area that I find generally needs far more work and interaction between those you have internally and your service providers like Merkle Science and other analytics providers, is this bit about what you do with the information that you receive, particularly from on-chain analytics reports. So you get this beautiful report that tells you all these sorts of things, or these sort of gives you potentially risk scores and so on, but there's still a need to sort of overlay that with institutionally what you're prepared to accept, and then to have the procedures and structures and tools to be able to then quarantine assets, freeze them, and so on. So policies and procedures is number one. The second one is then, of course, your actual tools. Generally what we're seeing is really any institution at scale will be using some sort of support or in-house build, but for KYC solutions for their client relationship management software that houses their information about clients, their on-chain analytics software, their market surveillance system, which has to be external from a Hong Kong perspective, as well as critically a travel rule solution. And I think that travel rule solution has actually been one of the most difficult for the industry as a whole, because we have still a fairly fragmented level of offering. Not all are GDPR and Hong Kong privacy law compliant. And so that tool is probably the one that I see needing the sort of most kind of uptick in development, but it's there. The third is people, MLRO, compliance, obviously, the senior management, the back office people who know what to do with the information, that understand how to report. You also then need, pillar 4 is your contractual frameworks that all gels. And one thing I'll note here is that Hong Kong has a special relationship between the exchange and then the custodian. The custodian is a separate legal entity. And so the interplay of the AML obligations between those two and being really clear in terms of who has the customer relationship is really important to sort out, because it informs how you do your AML. And then finally, the sort of 5th pillar is the iterate and repeat. Such a dynamic and changing landscape. And we're also seeing the sort of need to sort of continue to develop things. So be able to address new risk typologies, being able to respond to court orders and requests, like we're dealing with a Hashkey incident at the moment, and tracking crypto around the world to different exchanges. As an exchange, being able to handle those novel situations and then building them back into your policies is really critical. But documenting everything. So whenever the SFC comes knocking, you want to be able to explain how you dealt with, a red flag, how you, address certain risk scenarios. So I'll pause there. I could talk about AML all day, but I'm sure others have comments.
Yeah, anything you guys would like to chime in with as well?
No, I think Urszula's really summarized that. I mean, it's obviously a big factor for us at Hashkey. We just because you do have pseudonymous exchange, participants, it's not like you can walk into HSBC and refuse to give your name or anything like that, or whereas with us, I mean, that's you do have people like that. And it is harder to trace crypto. That's just the reality. So it is a different thing, but that probably again speaks to why the SFC does have the standards it has, and it does give people comfort. I mean, investor protection is extremely important in this field, so there's a good reason for the SFC acting the way it does.
Yeah, I mean, not much supplement from my end, but I mean, basically come down to the SFC applying there's same rules for same risk, same principle rule, right? So if the crypto industry has just traditionally been seen as a high risk for AML, and from that perspective, it makes sense from our point of view for SFC to require the level of AML procedure that's commensurate with, let's say, the banking sector, and apply that to the crypto sector.
No, I couldn't agree more with all of you. And personally, I am so excited to see how the AML space has developed. At Merkle Science, we specialize in building AML solutions, but I can tell you, it really shocked me how many times, when we started the company back in 2018, I think 1/3 of the companies that we approached had no compliance officer. Another third that we approach, if we were lucky, had a compliance officer, but that compliance officer had no compliance experience, and only a very small, the last 1/3 had a compliance officer with some kind of compliance experience. So I think, the space has definitely matured a lot more, and there's a lot more experienced compliance officers now who are more familiar with the technology. And at the same time, I think both the private and public sector are also starting to wise up as to how they can use the data that blockchain provides in a more meaningful manner, right? At the start, as well as today, a lot of firms are still focusing on monitoring, individual wallets and transactions. But with the transparent nature of the blockchain, monitoring and surveillance can actually be done more holistically at an entity or even a country level. And I'm happy to say, these are some of the initiatives that, here at Merkle Science, we've been working with a couple of our banking clients and regulator partners to see how we can build more macro level monitoring tools. And so to Ursula's point, a lot of people think that crypto is safe for criminals, but the truth couldn't be further, right? With crypto, every single transaction that happens on a public blockchain, I'll have that caveat, is publicly recorded and is available for the entire world to see. So it's very traceable, contrary to a lot of people's belief. So thank you, everyone, for your different inputs. Given that, Ursula, you made a comment on crypto custodians, I thought maybe I would take this opportunity to slip in one of the questions from the Q&A that had come in early on, which is, and this is really an open question to everybody in the panel, but can anybody talk about what is the regulatory landscape for crypto custodians? Does that differ in any way from, a typical VASP or trading platform?
Yeah. So some people will say, oh, there's no regime for custodians, and it couldn't be further from the truth. So Hong Kong is a regime for any custodian of any asset. So if I hold shoes on trust, my lipsticks on trust, crypto on trust as a business, then I need a company service provider license from the company's registry. So that exists and has existed for quite some time. It is not necessarily always needed if custody is sort of an incidental part of a certain business, but you need to be careful. But the other thing to know is that a custodian for an exchange operator is also what's known as an associated entity of that exchange operator, which means that there are certain obligations that the SFC imposes through the platform operator onto the TCSP. The final thing I'll mention is that there is also a trust company's sort of regime. Generally, it's at the sort of company level rather than a license, but TCSP, that's your key regime.
Yeah, the other thing I'd add is it's an interesting regime. We've talked a lot about the SFC, but the TCSP regime is actually administered by the company's registry, so it's actually a separate body. But having said that, say for us at Hashkey, we have an entity that's that holds a TCSP regulated by the company's registry, but it has to be part of Hashkey Group. We can't have a separate third-party custodian, which is interesting. I mean, in other jurisdictions like Canada, for example, you have to have a third-party custodian, so you have that complete separation. Whereas the SFC has said, well, we actually like having somebody under you that, you know, if there is any sort of issue, it's all under the one roof. So I mean, there's pros and cons for each, but that's sort of how Hong Kong works.
Yeah, I think the important point there is really the TCSP is really registry of trust companies. So I think the SFCs obviously, as we know about the VASP regime, requires the TCSP trustee company to be 100% owned subsidiary of the licensed exchange company. And the way that is set up is because that gives SFC a power into regulating the subsidiary company, which is part of the trading platform. The sort of the regulatory power and the requirement to obtain the TCSP license is much lighter than, let's say, getting the VASP license. So you can see that, you know, over the grand scheme of things, that's why right now the SFC is hesitant for companies to use a third-party custodian purely because the third-party custodian has a TCSP license. But what you would have heard from the SFC and also perhaps from the Hong Kong government is that there will be a new regime coming in. There will be a new license coming in, likely under the SFC, that will give the SFC or another body, and haven't really formalized that, but I think it may be the SFC, power to regulate crypto custodians. So that could come in, you know, perhaps in the next couple of years. And this is also something that we are looking forward to here at KPMG.
No, thank you. Thank you for sharing that. Personally, I wasn't even aware of half of what you guys had shared. So that was enlightening to me as well. Following along that train of thought, then given that, you know, that there might be potential regulatory clarity coming up in the future around crypto custodians in Hong Kong, and again, this is open to everyone, can any of you speak to what are the potential implications for firms that are operating in more grayer areas today, like staking or NFTs? And what is Hong Kong's stance, I guess, on DeFi and other emerging digital assets?
It's not so grey. I just want to be really clear. It's not so grey. If you have any law firm saying it's grey, find another one. But I'm sure others will have some more to say on that. But just it is possible to find answers on those things. And some things are genuinely still unregulated. Some things are definitely regulated, but not necessarily well enforced yet. But it's not that grey.
Yeah, I mean, to add to that, I mean, we don't like grey, and to be honest, I mean, and we, you know, grayness or you know, to be formal about it, lack of clarity is not good for the industry. It's not good for investors. It's not good for Hong Kong. If you'll permit me, Ian, I noticed Federico has actually asked a question. Would you argue that crypto companies seek regulated countries or unregulated countries? I mean, I can only speak for Hashkey, obviously, but we're in Singapore, Japan, and Hong Kong. Each of them has a very strong regulatory regime. We don't want grey. Investors don't want grey. I mean, we're trying to be, you know, if this is an asset class that's going to go mainstream and it's becoming increasingly mainstream, clarity is the most important thing you can have. So all of these things, I mean, staking, the SFC has been very clear about, you know, what staking is. You know, it's looked at other jurisdictions. You know, you've seen the SFC, you know, via its enforcement and its intermediaries division, you know, look at entities that are actually staking. NFTs, that's been clear as well. I mean, all of these aspects, I think, are good things. And you know, if anything, I wouldn't see that the information that's going to be released about STOs or derivatives being, you know, removing the grey. I think it's actually, you know, already refining what is quite a clear regime. And we've been very lucky in Hong Kong that the SFC has actually released the amount of guidance, been as involved in the industry as it has.
Yeah, so I think on this point, definitely. So actually, the SFC themselves has issued some guidance around this. I believe there's a circular issued a while back where they clearly talk about the risks of these sort of yield enhancing or earn staking, you know, type of programs. So it's really like Urszula said, it's really up to there are certain rules certain principle you will go through to see exactly where it fall into, but you will come to a conclusion at the end of the day. And the SFC has been pretty clear that, especially in the case where the program falls into what's called a collective investment scheme, it is definitely within the power of the SFC to regulate. So there are definitely ways SFC can regulate these type of activities. But of course, in some cases, they may not be currently under the supervision power of the SFC. To touch on your other point about DeFi, so there's actually a good resource for this. The Julia Long actually had a speech a while back where she touched on the part of DeFi specifically, where she said that, again, it's principle based. You're not looking at whether your protocol is issued within a centralized system, or if your protocol is issued on, the Ethereum blockchain as a DeFi protocol. They look at whether the control is centralized. They look at whether or not they can identify the people that's running the protocol, or running, the program. So it's very clear to them that they don't care how the technology is being used, but if there's a group of people or individual that is running this, this exchange, whether it's DeFi or not, and it will satisfy what is required. What is, the requirement, what is being regulated under the AMLO, which is an automated trading system. You will fall under AMLO. It does not say that just because you're a DeFi protocol, you're not regulated.
Got it. Interesting. So that's why we need industry experts like yourselves to point us in the right direction, because I didn't know any of that. So thank you guys for shedding some light on this. And closely linked to this topic, as a follow-up question, one of the things that I found really interesting was that the FSC actually recognized inside their regulatory documentation that crypto assets do have the potential to change their classifications, right? I think, we saw a huge debate around Ethereum, for example, when it was first launched, right? Was it a security, given that it was, issued as a utility token for people to pay gas prices? But very quickly, people started buying it for investment purposes. People are using it for payments. And so the SSC, points to the fact that, assets may be reclassified. And given the potential for reclassification of assets, do you guys have any guidance for these companies as to what are some of the additional compliance measures that firms should undertake as part of their review to make sure that they don't fall afoul of any of these laws unknowingly?
I mean, maybe I can answer that, given we've just been through the process. As I said, we've actually got the Type 1 and 7 licenses. So for anyone who isn't aware, a Type 1 license is sort of a broker-dealer license in terms of being able to offer securities. And a Type 7 is an automated trading service license. So that's really for security tokens. And then now we've had the uplift, which allows us to do that for retail. So I think, we at the moment, because we sort of came at it probably differently to 99% of the rest of the industry, in that we got our Type 1 and 7 first, and then we've gone under this BATP regime. But most people will be the other way around. So they'll actually be applying for the BATP regime. But then the SFC has also said, well, you should actually get the 1 and 7 as well. So, and if you don't, you have to sort of explain why. And the reason why they're saying that is because in case a token is, reclassified for whatever reason, you can say, well, that's fine, I've got licensing under both. Like we could actually do that. Because if you didn't, and you said, well, the token which I thought was not a security now is a security for whatever reason, then you wouldn't be able to carry out services anymore. And I mean, part of that is why the SFC has got a token admission and advisory and review committee. And that's the due diligence you're meant to do. But then you're meant to actually look at the tokens, do your due diligence, work out exactly what it is. Interestingly, there used to be we at Hashkey, we used to be governed by by the SFC saying before you submit anything, before you list anything on your exchange, you actually need to have a legal opinion from an external law firm. Now, we don't actually have to have that anymore, but that doesn't mean we don't. I mean, you can go to an excellent law firm like Urszula or someone like that who can give you that sort of assurance, and say this is a security or this is not a security, depending on what you're actually doing. But I mean, that's part of the due diligence you need to do. And even if you don't get that opinion, the SFC has said if we ask, you need to be able to justify why that is, why you think it's a security or not.
Yeah, I think what Jonathan said is exactly right. So the SFC is not saying that you cannot list security tokens on your platform. You can, as long as you have a Type 1 and 7 license, which they're encouraging all the companies to also get. But that also means that you need to follow the rest of the security and future ordinance that is applicable for securities. So there is the sort of, we can do this, but the framework still forming, I would say, because definitely SFC is considering a lot of aspects still around security token going forward. But if a firm wants to issue a security token, there are ways for them to issue the security tokens. Sorry, list the security tokens.
Thank you. No, I think that's been super helpful. Now I know we're kind of not running out on time, but we do only have about 12 minutes left. So I want to make sure that we manage to work through some of these questions that the audience has kindly put forth. So with that said, let's slowly start making our way through. And I apologize to members of the audience if we don't manage to get to your question, but we'll try our best. So with that said, we've gone through the question number 1. Let's jump straight to question number 2 from Mike. So in January, the HKMA and FSC issued a joint circular for virtual asset related activities. Based on this, what concerns with regards to regulatory overlap continue to be a concern? And I think with the audience questions, it's really open to any one of you to kind of jump on it.
I'm happy to tackle it. Okay, joint circular, what a beast. So for those who aren't familiar with this beautiful, joint initiative, firstly, it's joint, which is a great thing. So from a regulatory alignment and overlap perspective, we're talking about two titans of regulatory industry coming together, and we're seeing that more and more. The second thing to know about this is very much about all the other regulated entities besides necessarily just the exchange entities, but it's everybody else that is regulated by the HKMA and the SFC about how they interface, with the crypto sector. So how do they refer clients across to exchanges? Can they establish omnibus accounts? What else can they do? Do they need to limit to professional investors? What are the risk disclosures they need to give? Or how do they approach suitability? And what's really, I guess, a challenge about it is that it does put a lot of guardrails around it. And it also means that those institutions can't be funneling client leads or opening omnibus accounts with unregulated exchanges. So for those that are regulated, and we have a wonderful one with us today, that's a great thing, right? So they've gone to the trouble of being regulated, and they can send, they can receive flow from those entities. So those parameters are very strong. However, what's good about that is that it is clear. So if I go and speak to one of my banking clients who's wanting to offer, Bitcoin futures on CME, we have a very clear pathway around how we do that. I think some of the things within that could be a little bit fine-tuned. And the example I'll give you is if you're looking at how to apply suitability, you're looking at every circular that's been issued from 2009 to build your policy around, suitability. So it is a bit of a dark art to make sure that you're really factoring in all the expectations when you're reading that circular as well. But I would say it's an incredibly valuable resource for those that are regulated by the SFC and the HKMA.
Thank you, Urszula. Yes.
Maybe I'll go first. So I think this is actually this is probably the most referred to circular that we talk to our traditional asset manager and banking clients and private banks. So first, I think first thing to note is this circular definitely was issued prior to the finalization of the VSP regime. So you would expect to see this circular getting updated over the next couple of months, and that should be coming out soon. So the SFC is working on that, to my knowledge. The other thing to point out is obviously, a lot of the private banks or a lot of the asset manager that we speak to, some of the biggest concern around implementing the circular before is around knowledge tests and how to deal with complex product. Because as you know, right now under the circular, under the SFC framework, all crypto, token, cryptocurrency, everything is considered a complex product. And from their perspective, these are much more harder and much more process intensive to be able to offer to their clients. But I think one thing that you may find going forward is that approach may also change, because as you know, there are various types of cryptocurrency product right now. For example, there's the exchange traded crypto, exchange listed funds on the Hong Kong, on the exchanges right now that is allowed by the SFC, and those are usually seen as much riskier, much less riskier, and they're not. But then obviously there's the other tokens. But like Urszula put, basically one thing that's not going to change is that the SFC is going to want licensed corporations, anybody with a SFC license, to be dealing with only SFC licensed VSP providers. So they're not going to be open to you, any licensed corporation, to be using any unlicensed exchange going forward.
Thank you. In the interest of time, I'm going to try and work through these questions as much as possible. So I asked the panelists, let's keep your answers a little bit short, because at the end of the day, you don't want to give away everything, right? You want these people to come to you to asking for more, right? So with that said, let's move on to the next question from Niam. In regards to what Urszula said, does the Customs and Excise Department now take MSO applications from crypto companies?
Unless you are doing fiat remittance or fiat to fiat exchange, the CNED does not want to hear from you. So if for some crypto companies that will be relevant, for others, not at all.
Thank you. Would anybody like to tackle this very broad question of how can you compare the regulatory landscape between Singapore and Hong Kong? It is a very broad question.
I'll just go Singapore, think super broad, not as deep. So Singapore is tackling pretty much kind of every single possible activity, really going after sort of various P2P and DeFi related platforms, capturing more sort of non-custodial wallets than you will see in pretty much any other market, and really continuing to expand its coverage points. Not quite as deep, because we're talking about digital payment tokens, so slightly different definition, and also a lot of the controls are still being enhanced as compared to Hong Kong. I should say none of this is legal advice.
Great caveat, Robert. I think you wanted to chime in there as well.
Yeah, I think it's hard to sort of really get into the meat of this just in a short question, but the Singaporean regulation, the DPTSP, which is a handful to say for myself, is definitely very broad. It does touch on many of the same principles around governance, around the need to have cybersecurity, around the need to have particular licensing requirement, and particular around what the evaluation criteria are, how to save custody, how to make sure that the customers' assets reconcile on a regular basis, etc., etc. But I think, broadly speaking, I think overall, to my latest understanding, I think Singapore is still more reluctant to allow retail investors into this space, which is obviously Hong Kong is a different story here.
Yeah, I'd add to that. I totally agree with what Robert's saying in terms of the institutional retail difference. One of the things that always strikes me in Singapore is when you go to Singapore itself, you don't actually have the advertising that you see in Hong Kong on trams or in MTRs and things like that. So you can't actually advertise DPP services or DPP products in Singapore in the same way that you can here. That's not to say that people don't know about it, but it's just a very different approach with respect to retail.
For sure, and just to add just the last bit of color over there, yeah, Singapore used to be okay with crypto regulations, but I think about 1 to 2 years ago, they came up with a guidance that kind of required all companies to get rid of all their marketing activities. And so it's a big thing because, all the taxis had to pull down their Bitcoin posters, all the shops as well. So there's definitely a clear indicator that at least from a retail offering perspective, Hong Kong does seem to be a more attractive market, right? So maybe just one or two last questions from the audience. It is observed that the OTC market are not regulated. How can VAS keep their clients' money clean or identify the risk of, funds coming from, I guess, an OTC trader? This is
maybe
oh, it's AML. Should I go? Okay, it's KYC and it's on-chain analytics. That's the crux of it. It's travel rule. Yeah.
So the short answer is, yeah, it's technology can help you with that, right? So on-chain analytic vendors can, to a certain extent, give you some indicator of where the funds are coming from, right? So even if it's not a registered OTC, there should still be some indicator that it's coming from some kind of business entity, in which case you can compel your client to provide you with more information as to the source of funds. And from that aspect, travel will definitely be helpful in kind of closing that gap and requiring both companies to exchange information. So last question from the audience before I have one final question for the panelists as well. What are the basic requirements for crypto exchanges or custodian wallets to be registered, and where the registration, can the registration be verified by other institutions in case a crypto company applies for an account? So two-part question.
I assume this is talking about the capital requirement to apply for the virtual asset service provider license. So there are requirements. So there's a minimum capital requirement and also the minimum liquid capital requirement. So basically, you need at least $5 million Hong Kong dollar. That's the minimum capital requirement. The minimum liquid capital requirement, it depends on your business. I assume that's the question here. I'm not exactly, I don't really, maybe not too clear on this. And in terms of, whether others can verify the institution has applied for an account. If we're talking about, people outside the crypto exchange coming in to see whether the crypto trading platform has the minimum capital requirement, I think that would not be possible, but there are regulations and reports that need to be provided to the SFC in this regard.
Thank you. So with that, I'm very conscious of the time. We only have a minute left, and I want to thank all our audience for staying for the entire session, because I know oftentimes people start dropping off after a while. So appreciate all of you who are still with us. I just have one final question to the panelists, and I do want to apologize to those of you who have put in a question inside the Q&A, but we didn't have time to get to you. I will shortly be sharing my email inside the chat. So if any of you would like an answer to your question, feel free to drop me an email letting me know what your question is and which one of the panelists you would like it to be addressed to, and we're happy to facilitate that connection. But the last question that I have for the panelists, so given that we've talked a lot about the recent regulatory developments in Hong Kong, how attractive it is to certain type of businesses, are there any specific type of business or companies that you would recommend in particular to relocate to Hong Kong? And what are some of the advantages that they might have compared to other jurisdictions, right? So this is your one-liner to attract companies to Hong Kong. What is it? And let's start off with Jonathan.
One line: regulatory clarity and government engagement.
Robert?
I was going to say the same thing, just the support of the government. I mean, that's always going to be important.
All right. And last but not least, Urszula.
Ecosystem. There's so many players that are in this space.
Thank you. And I can attest to everything that they just said. So, as an ex-lawyer myself, regulatory clarity has always been, great. And I can also personally attest to the vibrant Web3 scene in Hong Kong. I've been there to a couple of events myself personally, and there's always a lot happening. So for those of you who are thinking about relocating to Hong Kong, I strongly suggest you reconsider it, not just because of the regulatory clarity, but because of like what Urszula mentioned, the vibrant crypto scene that's taking place over there. So with that, we come to the end of our Merkle Science webinar. Again, thank you everyone for staying back, and thank you to all my esteemed panelists for your insights and for participating in today's session. If there's any member of the audience who would like to reach out to myself or a member of the panelists, do feel free to write into my email, which I put inside the chat, and we'd be happy to connect you guys. So with that said, thank you again. Please stay tuned for future webinars by Merkle Science, and I wish everybody, a wonderful rest of your day. Yeah.
Thank you.
Thank you very much.
Thank you.
Gill.